Okay, for today, for Module 5, we'll be talking about management of the use of natural resources. Natural resources are anything that we obtain from the environment to fulfill human needs and wants. Some are directly available for use, such as sunlight and air, while others are not, such as mineral and energy resources. Natural resources are considered as assets or materials that constitute the natural capital of a nation. Except for those directly available, natural resources require application of capital and human resources to be exploited, meaning some natural resources need to be extracted, processed, refined for the realization of their economic value. In terms of management of natural resources in the Philippines, the Philippine Constitution, the Environmental Policy and Environmental Code set the framework for specific laws and implementing rules and regulations on the use of specific kinds of natural resources. The different agencies in charge of the various aspects of the natural resources management were developed. They need to update and revise laws and IRRs related to the functions they are specifically mandated to implement. Let's start with the land-based natural resources use management. For the forest resources, forests is the in the Philippines are not only a source of timber, but also an important habitat to diverse and exceptionally rich flora and fauna. The ancestral domains of the country's 12 million indigenous peoples are also usually located within forest lands. However, as seen in the table in your screen, from 2003 to 2010, there is a decrease of the forest lands. Now, the forest is one of the most valuable, replaceable natural resource of the Philippines. It is a source of raw materials, and if properly managed, it could yield significant revenues for the government. In terms of forest management, in the Philippines, the forest management may have passed through the following stages of development. Stage 1, large areas of forest were converted to farmland to support a growing population. Stage 2, the country sought to augment agricultural development by developing an industrial economy based largely on natural resources. Forest exploitation accelerated during this stage, resulting in a logging boom. Faced with diminishing forest resources, local forest based industries were forced to diversify or go out of business. In third and current stage, concerted efforts are being made to reverse the decline in forest area and quality and protect the country's remaining natural forest. The management mechanisms for the use of forest resources is governed by the Presidential Decree 705 issued in 1975. This is known as the Revised Forestry Code of the Philippines. This is a revision of the earlier issued Presidential Decree 389. PD 705 declared the adoption of the state policy that multiple uses of forest lands shall be oriented to the development and progress requirements of the country, the advancement of science and technology, and public welfare. These are the key features of PD 705. Land classification and survey shall be systematized and hastened so as to clearly segregate forest reservations from land open for other uses, defines areas needed for forest purposes, mandates the establishment of boundaries of forest lands, prescribes utilization and management scheme, multiple use, license agreement, license, lease, or permit, prescribes the measures shall be taken to achieve an approximate balance between growth and harvest or use of forest products in forest lands, requirement for inventory prior to timber utilization in forest lands, prescribes cutting cycle, annual allowable cut, duration of license agreement or license to harvest timber in forest lands, guidelines for size of forest concessions, and rationalization of wood or forest products industry, including incentives for wood industry. Under PD 705, the Bureau of Forest Development, now called Forest Management Bureau under DENR, was established and given jurisdiction and authority over all forest land, grazing lands, and all forest reservations, including watershed reservations. The Bureau was assigned to lead the overall management of the forest resources guided by implementing rules and regulations issued by the DNR. There are strategies being deployed in forest management. One is the community based forest resource management. Community based forest management agreement is a production sharing agreement between the DNR and participating people's organizations, normally for a period of 25 years, renewable for another 25 years, to provide tenurial security and incentives to develop, utilize, and manage specific portions of forest land. Another is the Philippine Sustainable Forest Management Strategy. This provides the framework for all forestry programs, projects, and activities. This framework is consistent with the provisions of the Philippine Constitution and supports the Local Government Code of the Philippines, RA 7160, the National Integrated Protected Area System Act or NIPAS law, and the Indigenous Peoples' Rights Act or IPRA law. Let's talk about now the mineral resources. Minerals are natural occurring homogeneous solids with definite chemical composition and highly ordered atomic arrangements. It is usually formed by inorganic processes. Any concentration of these minerals with a potential economic value that can be extracted at a profit is considered as a mineral resource. Since the Philippines is located within the Pacific Ring of Fire, Philippines is one of the world's richest countries in mineral resources. The country ranks fifth in the world in terms of total mineral reserves estimated to reach 1.387 trillion US dollars. This table shows the different estimates of the different mineral resources present in the Philippines. However, due to mineral resource exploitation, mining has always been associated with environmental degradation, and it is said to be among the first major causes of environmental degradation in the Philippines. The mineral resource exploitation began to grow in the last 50 years of the Spanish occupation and saw its boom in the form of large scale mining during US colonial rule. To address this, RA 7942 or the Philippine Mining Act spurred the development of the Philippine mining industry. This Republic Act declared as a policy that all mineral resources in public and private lands within the territory and exclusive economic zone of the Republic of the Philippines are owned by the state. The law underscores the following key provisions on the use of mineral resources. 1. It shall be the responsibility of the state to promote their national exploration, development, utilization, and conservation through the combined efforts of the government and private sector in order to enhance natural growth in a way that effectively safeguards the environment and protect the rights of affected communities. The exploration, development, utilization, and processing of mineral resources shall be under the state's full control and supervision, and that it may directly undertake such activities or it may enter into mineral agreements with contractors. Let's now talk the agricultural lands. The agricultural crop sector plays an important role in the economic progress of a nation. It provides food and vital raw materials for the growing economy. Materials needed for various economic activities come from agricultural crops. The crop sector likewise provides employment to a large number of Filipinos and supports other sectors of the economy like manufacturing, trade, and services by supplying the needed raw materials. The Philippines' cropland, freshwater, and coastal and marine ecosystems face significant and often severe problems of environmental degradation, both from the depletion of resource stocks and from pollution. Now, agricultural land degradation in the lowlands is a result of the intensive cultivation and can be offset by proper crop management practices. And in terms of management mechanisms for the use of agricultural resources, the policies of the state to enable those who belong to the agriculture and fisheries sectors to participate and share in the fruits of development and growth is stipulated in RA 8435, otherwise known as the Agriculture and Fisheries Modernization Act of 1997. This act provides for the utilization of the nation's resources in the most efficient and sustainable way possible by establishing a more equitable access to assets, income, basic and support services and infrastructure, and the state support to optimize production of rice and white corn, which is the staple food of the Filipinos. Another is the Comprehensive Agrarian Reform Law or RA 6657. This act provides for the application of the principles of agrarian reform or stewardship whenever applicable in accordance with law in the disposition or utilization of other natural resources. These include lands of the public domain under lease or concession, suitable to agriculture, subject to prior rights, homestead rights of small settlers, and the rights of indigenous communities to their ancestral lands. It likewise stipulates that the state shall be guided by the principles that land has a social function and land ownership has a social responsibility. Owners of agricultural lands have the obligation to cultivate directly or through labor administration the lands they own and thereby make the land productive. This time, we will talk about the water-based natural resources use management. The country's water resources in general are abundant, but access to fresh water in some areas is a problem. The National Water Resource Board has identified nine water critical urbanized areas where water is consumed intensively. These include Metro Manila, Metro Cebu, Davao, Baguio City, Angeles City, Bacolod City, Iloilo City, Cagayan de Oro City, and Zamboanga City. Now, the access to clean and adequate water is an acute seasonal problem in urban and coastal areas in the Philippines. The National Capital Region, the Central Luzon, Southern Tagalog, and the Central Visayas regions are the four urban critical regions in terms of water quality and quantity. The mechanism for managing the use of water is governed by the PD 1067 on the utilization of water resources under the following principles. All waters belong to the state. All waters cannot be subject to acquisitive prescription. The state may allow the use or development of waters by administration concession. The utilization, exploitation, development, conservation, and protection of water resources shall be subject to the control and regulation of the government through the National Water Resources Council, now called the National Water Resources Board. Now, PD 107, otherwise known as the Water Code of the Philippines, was issued in December 31, 1976. This presidential decree consolidated the laws governing the ownership, appropriation, utilization, exploitation, development, conservation, and protector of water resources. The key features of the PD 1067 are stated. It establishes the basic principles and framework relating to the appropriation, control, and conservation of water resources to achieve the optimum development and rational utilization of these resources. It defines the extent of the rights and obligation of water users and owners, including the protection and regulation of such rights. It adopts a basic law governing the ownership, appropriation, utilization, exploitation, development, conservation, and protection of water resources and rights to land related thereto, and it identifies the administrative agencies that will enforce the code, the lead being the National Water Resources Council, now the National Water Resources Board. This time, we'll be talking about the fishery and aquatic resources. Considering the territorial waters measuring as much as 1.6 million square kilometers and located in the world's fishing center, the Philippines is definitely rich in marine resources. However, the population of the Philippines has grown significantly, and with this, the demand for basic commodities has increased. The demand for fish, both for food consumption and other uses, has increased correspondingly. To meet the demand, there is an improved fishing technology being promoted. In return, it brought stress to the country's marine and coastal ecosystem, thereby affecting the fishery resource. Working on the mechanisms for managing the use of fishery and aquatic resources, RA 8550, otherwise known as the Philippine Fisheries Code of 1998, provides for the development, management, and conservation of fisheries and aquatic resources. It seeks to limit access to the fishery and aquatic resources of the Philippines for the exclusive use and enjoyment of Filipino citizens. Consistent with the objective of maintaining sound ecological balance and protecting and enhancing the quality of the environment, the Act aims to ensure the rational and sustainable development, management, and conservation of fishery and aquatic resources in Philippine waters, including the Exclusive Economic Zone or EEZ and in the adjacent high seas. These are the key features of RA 8550: conservation, protection, and sustained management of the country's fishery and aquatic resources, poverty alleviation and the provision of supplementary livelihood among municipal fisherfolk, improvement of productivity of aquaculture within ecological limits, optional utilization of offshore and deep sea resources, and upgrading of post-harvest technology. This time, we'll be talking about energy resources management. Natural resources are primary energy sources and take many forms, including energy like oil, coal, and natural gas, and renewable sources like wind, solar, geothermal, and hydropower. These primary sources are converted into electricity, a secondary energy resource, which flows through power lines and other transmission infrastructure to your home and business. Fossil energy are likewise converted to fuel for the transportation sector. The country's energy self-sufficiency level in 2013 declined to 56.7% from the previous year's level of 60.6.2%. The reduction was attributed to a decreased share of natural gas and an increased importation of oil to meet the increasing domestic requirement for the transport sector, as well as coal and other finished petroleum products for power generation. In terms of energy resources, we have coal, oil, and gas. For coal, worldwide, coal is a sought after energy source. It has the largest reserve and is often the cheapest of fuel options. The Philippines has a vast potential for coal resources just awaiting full exploration and development. Oil and gas, these potential petroleum resources of the Philippines are located in the 16 sedimentary basins situated all over the country. So we have a lot of potential petroleum resources in the Philippines. Talking about the renewable energy, harnessing and utilization of renewable energy is a critical component of the government's strategy to provide enough energy for the country. Among the renewable energy resources present in the country are hydropower, geothermal power, biomass, solar, and wind power. The management of the use of indigenous energy resources is governed by the provisions in RA 7638, otherwise known as the Department of Energy Act of 1992. This act aims to ensure continuous, adequate, and economic supply of energy with the goal of ultimately achieving self-reliance in the country's energy requirements. The key features of RA 7638: integrated and intensive exploration, production, management, and development of the country's indigenous energy resources, judicious conservation, renewal, and efficient utilization of energy to keep pace with the country's growth and economic development, and taking into consideration the active participation of the private sector in the various areas of energy resource development. Rationalized, integrated, and coordinated implementation of various programs of the government towards self-sufficiency and enhanced productivity in power and energy without sacrificing ecological concerns. Now, the Department of Energy, being the lead implementing agency for energy resources management, issued implementing rules and regulations, or IRRs, which contain details on how this and other provisions of the law is implemented. Now, we will proceed to another section of our discussion for today, monitoring, and evaluation of the use of natural resources. The monitoring and management of the use, stocks, and quality of natural resources are undertaken by mandated government agencies. However, there is a need to improve disclosure of the systems and standards used as well as the results of the monitoring. Highly technical survey methods, such as those for mineral resources, tend to limit the public participation and understanding of the status and trends on the use of the natural resources. As a concrete step towards promoting good governance in the extractive industries, the Philippine government expressed its commitment to participate in the Extractive Industries Transparency Initiative through Executive Order 79 and 147. The EITI is a global standard of transparency that requires oil, gas, and mining companies to publish what they pay to the government and the government to publish what they collect from these companies. The adjudication of disputes relating to appropriation, utilization, exploitation, development, control and conservation, and protection of waters is among the function of the National Water Resources Board, an attached agency to the DENR. Meanwhile, for the mining sector, it is the Mineral Rights Adjudication Board that hear and determine questions, disputes, and other matters arising out of the application of the Mineral Act or the Mining Act and its related regulations. The Supreme Court Rules of Procedure for Environmental Cases issued in 2010 apply the laws on natural resources use. As such, related disputes and conflicts can be resolved also through court proceedings through this procedure. For this chapter, we talk about the overview of the current system of management of natural resources, including management mechanisms, specific challenges, and opportunities focus on the following. Land-based natural resources, this includes forest resources, mineral resources, and agricultural lands. Water-based natural resources, that includes the water itself, fishery, and aquatic resources. And lastly, the energy resources, this include coal, oil and gas, and renewable energy. We also talk about management mechanisms. For land-based natural resources, for forest resources, it is governed by the PD 705 or the Revised Forestry Code of the Philippines, mineral resources or the RA 742 or Philippine Mining Act that governs the mineral resources. For agricultural lands, it is the RA 8435 or the Agricultural Modernization Act of 1997 and RA 6657 or Comprehensive Agrarian Reform Law that governs these resources. For the management mechanisms for water-based natural resources, PD 1067 or Water Code of the Philippines govern the use of water. Meanwhile, RA 8850 or the Philippine Fisheries Code of 1998 govern the fishery and aquatic resources use. For the management mechanisms for energy resources, the RA 7638 or the Department of Energy Act of 1992 governs the management of indigenous energy resources in the country. We also talk about adjudication of disputes on water-related concerns is a function of the National Water Resource Board. Meanwhile, Mineral Rights Adjudication Board for mining-related concerns. And that ends our Module 5, the management of the use of natural resources.